I'm Deepika Prakash from National Law University, Delhi, and this presentation is about other laws affecting companies under the corporate law. This presentation will elaborate on laws other than Companies Act 2013 which have an impact on the companies that function in India. The major focus of this presentation is to give an overview of all such laws and their respective provisions which have a consequence on the functioning of a company form of organization in India. Company form of organization is by far one of the most ingenious and successful business organizations worldwide. Over the years, it has taken complex forms, evolved to suit the needs and objectives of various businesses while maintaining its basic characteristics like limited liability and perpetual succession, which are one of the appealing features as compared to other forms of business organizations like sole proprietorship and partnership. The history of regulating companies in India starts with the Joint Stock Company Act of 1850, which was subsequently replaced by the Act of 1857, more in line with the English Companies Act of 1855. The first comprehensive Indian Companies Act was passed in the year 1866, which was amended on several occasions. Subsequently, based on the Bhabha Committee report, India passed the Act of 1956. Now, as corporate India continues to evolve at a lightning speed, it is imperative that all the divergent range of stakeholders in it are well protected and represented. In India, company form of business in all its kinds are primarily regulated by the Companies Act 2013, which has recently substituted its predecessor, that is the Act of 1956. The new Act deals with various dimensions of companies, giving detailed provisions for their regulation and compliance and raise the bar on governance. However, companies in India are regulated by other diverse laws as well, and the intertwining of these laws create a dynamic structure of regulations which makes corporate environment more transparent, simple and globally acceptable. Some of these laws are the Banking Regulation Act of 1949, the Securities and Exchange Board of India Act 1992, the Securities Contract Regulation Act of 1956, the Securitization and Reconstruction of Financial Assets and Enforcement of Securities Interest Act of 2002, the Competition Act of 2002, the Foreign Management Exchange Act of 1999, the Insurance Act of 1938, the Income Tax Act of 1961. Then there are various labor laws, various intellectual property rights, various environmental laws, and finally the latest law, the Limited Liability Partnership Act of 2008. Let us briefly discuss them. The first law that affects companies in India is the Banking Regulation Act of 1949. It is the main law regulating banking in India. However, this act does not purport to codify the law on banking. It merely lays down the regulations for the functioning of the banking companies and corporations in addition to those already presented in the Companies Act. Now, there are three types of banks in India. First are the nationalized banks like the State Bank of India and the Bank of Baroda. Second are the banking companies, which include private banks like ICICI and HDFC. It also includes foreign banks like Citibank And finally, there are cooperative banks like the Cosmos Bank. Now, what does banking mean? The business of banking in India means that the bank must have three features. First, the ability to receive money as deposits. Second, the ability to honor customers' check. And thirdly, ability to grant loan. If a company does not carry out all these functions, then it will not be called a bank. The Part 2 of the Banking Regulation Act of 1949 defines and lays down the business of banking companies. Section 6 elaborates on various forms of business in which such companies may engage in. Few such activities are: first, borrowing, raising or taking up of money, the lending or advancing of money either upon or without security. Second, bills of exchange, hundis, promissory notes, coupons, drafts, bill of lading, railway receipts, warrants and other instruments and securities, whether transferable or negotiable or not. Third, providing a safety deposit vault, the collecting and transmitting of money and securities. Fourth, the effecting, insuring, guaranteeing, underwriting, participating in managing and carrying out of any issue, public or private companies. Now, the Act further lays down rules regarding appointment of board of directors and the chairman, licensing of a banking company, its capital, its loans and advances, and the Reserve Bank of India's power on banking company, to name a few. Therefore, a company which is interested in starting banking functions must be well versed with these regulations. Now, the Securities and Exchange Board of India is constituted in accordance with the provisions of the Securities and Exchange Board of India Act of 1992. The Act states the functioning of Sebi to be: first, to protect the interest of investors in the security market, to protect the development of and to regulate the security market itself. Therefore, Sebi is the regulator of the securities and exchange market of India. The Act is divided generally into various chapters, and these chapters mostly deal with the establishment of Sebi, the powers and functions of the board, prohibition of manipulation and deception devices, insider trading, and provisions regarding substantive acquisition of securities. The Act also lays down penalties for the contravention of the Act, Sebi's power of adjudication, and the establishment, jurisdiction as well as procedure for the Securities Appellate Tribunal. Now, moving on to another law, the Securities Contract Regulation Act 1956 is another vital legislation which is applicable and affects companies in India where their securities are listed on stock exchanges. The object of the Act is to prevent undesirable transactions in securities by regulating the business of dealing in it. The Act lays down provisions for creation and recognition of stock exchanges, contracts in securities and listing of securities in stock exchanges. The aim is to keep the functioning of the stock market transparent and to prevent undesirable contracts in security market through a due process of recognition and continued supervision. Now, this Act can be majorly divided into two parts. First relates to recognizing of stock exchanges and second relating to penalties and procedure under the Act.